I first like to introduce myself and then my co-host, Lukey Forbes, and I'll have him introduce himself. And then we're going to um, provide a little bit of a legislative review of where we are on the state of play in Albany. Just a few minutes. I think all of you would probably appreciate that. And then thereafter, we're going to do a discussion around clean slate and then bail reform, and then some other topics thereafter. So my name is Peter Cook. I'm the executive director of the New York State Council of Churches. We've been around since 1893, and we are really about the work of addressing structural racial and economic injustice in our state and in our world. And so it's really appropriate that we host this seminar today on the question of criminal justice reform, particularly as it relates to clean slate, bail reform, full conviction, and also a little later on about prison wages. Before we go any further, Lukey, would you introduce yourself?
Hello, everyone. My name is Lukey Forbes. I'm the Civil Rights Coordinator at Catskill Housing Coalition. It's a pleasure to see everyone on this call to just hear a few updates about our legislative priorities and what's going on in Albany. And I'm glad to see a few familiar faces on the call as well.
Great. So we really appreciate this opportunity to work with Lukey. He's really been an amazing leader in so many ways. And he was the one who really strongly urged that we have this call. So thank you, Lukey, for that. So I'm going to go through a series of topics that are before the legislature right now. Pardon my voice, it's a little froggy. I'm still trying to get over a little bit of a cold. But as you know, the state budget is due on April 1st. It does not look like that's going to happen. It could be more like April 4th, but I am hearing rumors that they might take 2 weeks past April 1 before we get a final budget. I hope that doesn't happen, but it could happen because the legislature and the governor are so far apart on so many issues. So I'm just going to hit a few of them. One, with regards to housing, the Council of Churches has taken the position that the governor has in her compact is requiring municipalities all over the state, places like Long Island, Westchester County, Buffalo, and other locations, to increase their housing supply by 3% every 3 years for downstate communities and 1% every 3 years for upstate communities. We think that the governor was correct in requiring municipalities to do this, but she gives them a lot of latitude to be able to achieve those goals. And we also know that it doesn't have as many affordable housing components as we would prefer. On the other hand, we have proposals for tenant protections. One is called good cause eviction, which says that you can't evict people for just any old reason. You have to have good cause for eviction. Also, housing access vouchers, which provide people with a subsidy so that they don't have to spend more than 30% of their income on housing. And there's also some debate about how to provide legal representation to people in housing court who might be facing eviction. The problem up to until very recently was that the liberal senators within the legislature sort of caved to the suburban lawmakers and said that we are not going to require municipalities to change their laws, but we're going to offer an incentive to do that. And that incentive is proven to be totally ineffective.
Shocker.
So, so what we are looking for right now is a grand bargain where the governor's restrictions are combined with tenant protections for a total housing package. And we think that there's a good chance that that could happen. I would not have said that last week. Secondly, with regards to immigration, there's a proposal from the governor to provide $1 billion in relief for those seeking asylum in New York. Most of that money is for New York City, and most of that money goes towards temporary shelter. There's only about 30 billion in that, 30 million in that proposal, which would help people upstate, which we think is a problem. However, it doesn't look like the more structural proposals that we are supporting to try to deal with immigration in general are getting a ton of traction, but it's a little uncertain. But those proposals are the right to representation in deportation proceedings, bridge unemployment, which would provide some compensation to people who were previously incarcerated or who are undocumented or self-employed or very small business owners. It's called the Unemployment Bridge Program. We also are looking for non-cooperation with localities with ICE, language access to broaden the languages that are available to people when they're trying to navigate services, and also some expansion in the Office for New Americans. Of all those I've mentioned, the expansion of Office of New Americans looks like it has the most traction. With regards to fair wages, the governor has proposed a wage increase, but really it's basically indexed to inflation no more than 3% after people hit a $15 an hour target. The counter proposal is to have a large adjustment in the wage, so maybe more like $21.25 an hour, and then index it thereafter. So there's a major dispute about that right now in the legislature. With regards to climate justice, there's a proposal for an all-electric bill that requires buildings, new construction to be electrified. And the proposal from the legislature is considerably more aggressive than the governor, who's also proposed this, but has a lot of exceptions and carve-outs that could sort of render this requirement somewhat meaningless. In addition, there are two funding bills that are before the legislature. One is a $10 billion climate bill that would help with um, trying to bring us to a clean energy future. And some of that money would go for other non-related environmental things that are not related to the environment. And the second is what we call a Superfund bill, which would tax or charge fossil fuel companies about $3 billion a year to go towards remediation right away, and particularly help communities that were affected by environmental racism. It's really unclear right now where everybody's going to come together, although probably the all-electric bill has the greatest chance. There's also a proposal to expand the child tax credit to apply to kids who are under the age of 4. Incredibly, we do not provide a tax credit if you're a family who has a 3-year-old, a 2-year-old, or a 1-year-old. Don't ask me why. We've been trying to turn this around for a long time. It looks like this year that's possible. There's also a proposal to try to give a one-time increase in wages to childcare workers, and it's a bridge step towards trying to come up with a universal childcare scheme for New York, which we would prefer, but we're not there yet. Something closer to what is already happening in New York City. I'm sure there are other things that people care about. One other thing is we are trying to, encourage an increase in taxes at the very top, as we always do, to deal with massive wealth inequality in our state. And we also are trying to stop a lot of tax giveaways to corporations who don't use this money in a very productive kind of way, which we think is wasteful. So with all of that, I'm going to stop. I'm sorry, that was kind of a fast little overview, but I just thought you'd like to hear the state of play as we see it right now. And I'm going to turn it over now to Lukey Forbes, who is going to lead us in a conversation about Clean Slate.
Hello, everyone. Again, just so glad that everyone can just take this time and join us for the conversation. Clean Slate is really something that is important to me as someone who's formerly incarcerated. I myself was incarcerated at the age of 15 years old. And after doing 7 years and being about to be 29 now, my felony is something that still excludes me from really being able to participate in a lot of things. About 44,000 different restrictions exist for a person who has a felony in the United States of America. So I'm going to pass it over to another one of the steering committee members, Kate Wagner Goldstein, who is a part of the Legal Action Center, who is going to speak around Clean Slate and just give you all a quick overview around what the bill does and just a few updates that we were recently able to submit as well. Again, thank you all for joining us.
Hi, thanks so much again for being interested in Clean Slate. And I recognize a number of your names from past Clean Slate events. So I know a lot of you are coming into this with some background already, but I'll give a quick overview. Happy to take any questions if that's helpful. Basically, the Clean Slate Act would provide automatic civil sealing of conviction histories after people have past a waiting period. So basically the concept is after a period of time, people should be able to move past their convictions. And so after a 3-year waiting period for misdemeanors and a 7-year waiting period for felonies, convictions would be sealed for most civil purposes, which are, purposes like jobs and housing. There are a number of exceptions carved into the act that have come through, sort of various stages of negotiation. And so there are exceptions to the ceiling for certain jobs that have been deemed by law to require tighten background checks, so jobs with fingerprinting requirements. And then similarly, there's also access to records for law enforcement and legal purposes. But for most civil purposes, allowing people to move on with their lives, fully participate in their community, achieve more of their potential, records would be sealed after these waiting periods. I'll also just note, for those of you who have been following Clean Slate more closely, there was a recent round of amendments in the last week or so, and those basically were largely technical, but addressed some issues that had been raised by the state ed department around some of the licenses that they oversee relating to healthcare fields. And so those added some exceptions for those fields because they had not previously had them. Yeah, and you know, we are basically at this point really pushing for passage as soon as possible. As you may know, this is a bill which has had really strong support from a lot of sectors. It's a bill that has brought people together through business leaders, labor leaders. They don't often see eye to eye, but this is a bill where they do. Faith leaders have been tremendous in this, and we really appreciate the support that we have gotten from faith leaders, civil rights advocates, the bar associations of both New York City and New York State have supported this bill. And so this is something where, like, across professionals working in the legal sphere, in all these other spheres, people have really come together to support this. And so we have gotten very close to passage a number of times. We think this session, we should absolutely be getting this bill passed. We're hoping in the next couple of weeks. And so we're pursuing passage both through the budget, as just discussed, recognizing, you know, the incredibly frustrating way that the budget is moving forward this year. And then also pursuing trying to pass it through the legislature. So there's sort of these two different tracks that you can get it passed on, either in the budget bill or the Senate and the Assembly passing it themselves and then sending it to the governor to sign. And we are working on both tracks, trying to get this passed as soon as possible.
As Kate was also saying, we were able to get about 15 municipalities to support this. We're really encouraging our assembly members specifically to support it. It was passed in the Senate last year and not the Assembly. And what I'm going to do is drop in the chat a link for you all, if you would like to engage in taking action virtually. There's a link for you to take action. It'll help you contact your legislators in order to really encourage them to also get on the bill. And if you have a relationship with a legislator, specifically an assembly member, we encourage you to also encourage them to not only sign on the bill if they're not signed on, but really speak up. We're really trying to get it on the codes committee in the assembly right now. We're just standing outside of their office, handing out support flyers to those who are in support, encouraging those who aren't in support to get onto the bill and bring it up in that committee. Again, if you have any relationship with legislators, we just ask that you pull on them to really get behind Clean Slate. This has been something that's been referred to as a no-brainer bill and will help New York families and economy really be able to rebuild. And we'll just go on to the next conversation. Thank you.
Great. Thank you. Lukey, would you like to introduce our next speaker, where we're going to focus not on Clean Slate now, but on the question of bail. We wanted to kind of not confuse those subjects, but we want to ask people if they have questions, which we're going to do after we're done with bail with regards to both Clean Slate and the bail bill. So, Lukey?
Right now, I'm waiting on Alana to jump on to the conversation to really be able to speak on bail. Again, for those who are listening, bail and Clean Slate are two separate things. They aren't in the same kind of conversation. Clean Slate is more of a bill that will help the economy. It's even looked at as a housing bill, and it's something that will help repair families. Bail reform is a separate option, a separate factor that has to do with current court reform. clean slate being something that happens upon re-entry once a person has been into society for an extended number of time and is not under like a new infraction or anything like that. Two separate things. Just really wanted to clarify that, as they're in the same conversation. However, they are two separate conversations. But Alana currently isn't able to get on until around 6.
Okay,
Is it, I had one thing to add if we have a minute now to
yeah,
add it.
let's do it.
Okay, and so when you go to the link in the chat that Lukey dropped there for take action, one thing to do is to check if your assembly member is already sponsoring the bill. If they are sponsoring the bill, it's actually a great time to say how much you appreciate their support and specifically ask them to talk to leadership about the importance of this bill, because in many ways, it's the people who are our biggest champions who we're really looking to engage right now to say, please speak to leadership, please tell them how important it is to get this passed now. So I just wanted to add that ask. And I know Lukey was referring to that before, but just, to some degree, if you're in a place where you already have somebody who's supporting, that's great. And to really drive that home if you can. And then, right, also, if they're not yet sponsoring, asking them to join in on that bill. And if I'm going to drop in the link. That was my other thought, was I'll drop in the link that lists who's currently sponsoring the bill so that you can check there. Basically, it's the link to the bill. And then if you look under the section that says co-sponsors, you can see if you find your assembly member there. Thanks for letting me add that.
Okay, I see that Alana has joined us now. Welcome, Alana, but I want to just let Neil ask his question here.
Yeah, I just want to ask you a simple thing that probably all the time. What is the cost? Because it is in the budget. And the cost upstate is different than the cost downstate. Is that a problem? The cost?
Are
Can
you
hear
asking
me?
about the cost of implementing Clean Slate?
Yes.
Yep. So, it's hard to tell at this point exactly what the cost is. The Senate budget does provide $1 million for implementation across the state. And so that is currently in their budget. And I think that that's something that could potentially be negotiated, but basically the cost would be the sort of what the expected cost is for across the state, recognizing, as you say, that the different courts, the different courts in different parts of the state may have some different implementation challenges. So it is true, it'll play out somewhat differently, but it should be applied across the state once they do give that final number.
Okay, I have one more question on Clean Slate, and then let's go to Alana. And that is that, as you know, we've got right up to the wire vote in the last 2 legislative sessions. And then we had some legislators sort of freak out at the end and suggest that they wanted even longer time periods before this law would kick in, which I thought were actually rather unreasonable, to say the least, and also concerned about reporting for like schools and religious institutions. If somebody had some kind of a criminal record that might come to bear on their ability to carry out their responsibilities in those settings. Could you say more?
Was that for me?
Well, Katie, but if you
Okay.
know about this, Alana, too, great. We're on Clean Slate right now.
Yeah, I was confused. No, that's all Katie.
Sure. I mean, one of the things that has been really frustrating is we have now gotten so close multiple times. And so as we saw last session, there's tend to be this sort of flurry of very specific issues that get raised at the very last minute. The main thing I'd say is that in each of these cases, there have typically been sort of ways to address the issues that are coming up. Often, as you were saying, it's around like I mean, sometimes it's about just simply saying the principles of this campaign are that people should have access to sealing as, within a reasonable time period. And so these time periods shouldn't be lengthened anymore. So sometimes it's about stating the principles. And then other times it's about, oh, well, there is this particular issue for this particular field. The other one that you were pointing to was that there was an issue around private and religious schools having different employment processes than public schools. And so people were raising concerns about would there be similar procedures put in place. And so that's the kind of thing that there have now been amendments that have addressed, but also is the kind of technical issue that can typically be addressed pretty simply. And so one of the challenges is sort of the ways in which we can kind of hold things up and become a talking point. And so I think it is something that we have seen, and that to some degree, I think is often a distraction more than a really substantive issue. And so often the goal is just to sort of try to be able to quickly address it and bring attention back to the bigger picture issues. I don't know if that lands with you, Peter, in terms of, how it has been possible to respond, but it is something that has come up a few times, especially as we've gotten close a number of times.
So you feel as though this time you've been able to head off some of this stuff that makes it more possible it's going to pass?
Yeah, I mean, I think we have now had so many, we have now addressed a lot of these things that have come up. I think it is possible that there will again be a sort of particular group that raises a particular issue, and our goal will be to really try to talk again about the sort of broad principles, and that we really have done a lot of looking for these different kinds of issues that come up, but generally that they are something that either can be addressed in a pretty technical way, or that they are, sort of potentially distractions. So I say both, that I think we have done a lot of work to address the kinds of things that would come up. I don't think that there should be significant other issues that do. And at the same time, I think that a tactic sometimes that comes from people who otherwise don't want the bill to pass is to point to sort of technical issues or sort of these details that can be used for talking points, but to some degree are a distraction.
Okay. So thank you, Lukey. Would you like to formally introduce Alana?
Yes, this is Alana, and she is the director of New York State for Forward US. And she's here to speak on and give some clarity around the governor's proposal to changes around bail reform.
Hi, everybody. Thank you so much for having me. Sorry if the noise is in right now, and a lot of us are here trying to push back against the governor's proposal to roll back bail reform. So right now, the bail law was changed in 2019 to make it so that on a good wealth of cases, judges cannot set bail. A lot of these are misdemeanors, certain non-violent felonies, things like that. And for the cases where judges can still set bail, judges can only do so if they find that setting bail is the least restrictive condition that would ensure appearance to court. This is a standard that has been around forever, especially the ensure appearance to court part, even before bail reform. Bail was never meant to punish people. It was never meant to determine whether or not someone is quote unquote dangerous, because we know that, there's no way to do that. So when judges try, they end up using sort of a lot of racial biases and things of that sort. Right now, the governor's proposal is to eliminate that entire standard. So making it so that for cases where judges can set bail, that they can do so for whatever reason they please. There's no standard at all. So basically a judge can decide, well, I don't like the crime that this person is charged with. They may be innocent, but I don't like the crime. It gives me the ick. I'm gonna set bail on this person. They can decide that they think this person is dangerous for whatever reason that they make that decision. They cannot like the way that somebody talked to them, and they can decide, okay, for that reason, I'm going to set bail on that person. And so we've been really concerned about this proposal. And so we've been in Albany every day this week. There's a big lobby day happening on Thursday where there are going to be people coming from across New York State to push back against it. And so we hope all of y'all can come and participate. What I can do right now is throw the information about that in the chat, because we have both a lobby day and then there are also, there's also a call to action tool that people can use to call their legislators and say not to roll back bail reform, because this is something we're really concerned with, especially, we've seen how bail reform has done a lot of good things. Like there's 24,000 people who have been released because of bail reform, 1.9 million more nights that are being spent at home rather behind bars. And we're also seeing how bail reform is not causing a rise in crime. Study after study has shown us that bail reform isn't leading to a rise in crime, isn't leading to a rise in rearrest. So it's really doing nothing but good for people in New York. So I'm looking for those links right now so I can drop them in the chat so that folks can get involved. There's about a week left before the budget is due. The governor's trying to ram through this proposal in the budget. So that's where, and anything we do this week is super helpful. So I'm going to go ahead and put a call to action in here, and I'm happy to answer any questions.
Can you address the dangerousness in the law, in the bail law? Because if they want to talk about dangerousness, it implicits racism and bias. Could you explain that dangerousness?
So, Alana,
Sorry about that. Yeah, thank you for asking that question. So right now in New York, judges they can't consider dangerousness, quote unquote dangerousness, when deciding whether or not to set bail. The only reason to set bail is to ensure someone's appearance to court. And that's a good thing, because we've seen in places where judges are allowed to decide dangerousness that it ends up resulting in more Black and brown people being incarcerated. And the reason for that is because there's no actual way to determine whether or not somebody is dangerous. So what judges do is they rely on their biases. And a lot of judges, like, their biases make it so that they look at somebody who is Black or brown and determine that that person is quote unquote dangerous. And we've seen a very similar thing that's happened with risk assessment tools that claim to be able to predict this, but instead what it measures is a lot of sort of background elements that end up incarcerating overly Black and brown communities. And we've also seen, there was a ProPublica study that showed how, when dangerousness was attempted to be tracked in these studies, more times than often they got it wrong for people who are Black and brown. So inserting dangerousness into the statute would be really devastating. And not to mention the thought of inserting the lack of a standard right now that the current proposal has is really going to end up being a proxy for dangerousness.
I have a question.
Yeah.
I would like to, in reference to what you're saying about dangerousness and with the reform bill, we look at how when the reform bill was implemented and it was meant, like you said, to not marginalize or be unjust to certain communities or groups of people. But when you see, like we currently see an ongoing trend, unfortunately, that is like a revolving door of those who's continuously doing certain crimes. Now, I know that when the reform was done, it was supposed to specifically be accordingly to certain crime issues or what have you, that will prevent the injustice that was put upon a group of people or community, or like you said, Black and brown communities or folks. But the thing is, how do you try to fine tune it where it will continue to be what it was meant to be, where it will allow the proper justice to be served towards people who was unjustly being targeted, to making sure those who are continuously doing these criminal acts that's taking advantage or that particular reform is giving them the opportunity to continuously to do these ongoing crimes because it appears that there's no consequences to their actions. We want this to be, because I was all for the reform bill, but my concern was, or is, should I say, the fact that how there are those who are taking advantage of this bill that is not that is allowing them to continue to go do a crime and then come out and do that crime again. So where do we draw the line? Because I don't want to see the bill put in jeopardy where it goes back to where we were from the start, but keep it intact where those who it seems to be taking advantage of this bill and still doing these same crimes because they realize that they're getting away with certain things. And I just want it to be, I just would like to see where it's fine-tuned to properly serve its purpose, but not allowing those who's out there doing wrong and think that they will get away whatever crime they're doing because the reform bill was specifically for those who we found to be innocent or unjustly served against the law. And how can we find that? Because it becomes a situation in the
Yeah, I hear
concern
what
of the
you're saying.
community.
Sorry, I wanted to jump in because I hear what you're saying, and I hear so many folks who have this real concern with crime in the community. Like, we've seen rises in crime happen across the country. We've seen them happen in places that have bail reform, in places that don't have bail reform, blue states, red states, all across. And there's a whole sorts of reasons for that. And the thing is, it's something that concerns me. It's something that concerns a lot of folks who live in my community.
Mhm.
And, when we think about how to address the crime, I always think as somebody who is an attorney and as somebody who looks at data for a living, like, I want to look at the data and see what the data shows about what is causing crime and what isn't. And what the data shows is that this issue that you're speaking of, that's not to say it's not an issue, but it's not bail reform that's doing it. We did an analysis that specifically looked at cases that were impacted by bail reform. And we looked at what the rearrest rates were for cases versus what they were for similarly situated cases before bail reform was passed. And we saw how bail reform, the rearrest rates were the same. So we know that bail reform isn't leading to a rise in crime. Study after study has shown this. The Mayor's Office of Criminal Justice did a study showing this. The Office of Court Administration did a study showing this. Same results, no rise in rearrest, no rise in crime. Similar study came out with the Comptroller's Office, the Division of Criminal Justice Services, which is an agency that is actually overseen by the governor's office. So we see all the data that shows bail reform isn't leading to a rise in crime. So by continuing to blame bail reform, something that has saved so many people and had so many of the benefits that you're talking about, and eliminated so much injustice, we're really distracting from looking at the issue of crime that we're all concerned about. And there are lots of things that could solve crime that we're not looking closely enough. Like, we're not looking at the fact that, Medicaid expansion was something that reduced arrests from 20 to 32%. We're not looking at the fact that expansion of summer youth programs, doing that is something that also reduced crime significantly. And so bail reform, it's done nothing but good. It really has. And that's not to say that there aren't tragic things happening every day. That isn't to say that there aren't people getting rearrested significantly every day, but it's not because of bail reform. And the more we keep looking at it, the more lives we're going to hurt. 19 people just died in Rikers Island last year and many of them because they were because of cash bail. So reducing crime, it's not going to happen by looking at bail reform. What looking at bail reform will do is harm more lives, and it won't address crime at the same time.
Yeah, because that's why I wanted to ask that question, because like I said, I was for the reform, but I just wanted to make sure to see to it that it wasn't so broad that it took away its purpose of why it was placed, as opposed to it being stated or like I said, being taken advantage of and taken away the whole purpose and reason why, because you find those who seem to me taking advantage of the fact that this is being used as their key to continue to do the criminal acts. And that's not what it was purposely there for, where they think they can get over because that reform is there with no bail and everything, as opposed to what its real purpose was. So me along with others who I spoke to, just don't want that confusion to be there, because it seemed like there was a confusion brewing up in it.
Yeah, and the bail law, like, it's not so broad. That's the thing. Like, this I mean, there are a lot of people where bail still can be set. For example, there's one provision of the law that specifically addresses that situation you're talking about. If somebody is out and then they are alleged to have committed another crime the second time, the judge can set bail no matter what the crime is, if it's alleged to cause harm to person or property, which, to be honest, is most crimes. And so it's not super broad. And if it were, there'd be a lot fewer people dying in Rikers Island right now.
Thank you for answering my question. Appreciate it.
Thank
Hey,
you.
Okay, I have a question.
Yeah.
I think with bail reform, we had a lot of petty thefts, petty larceny, and even in my area, a couple of establishments have closed down because of it. And I think we have to look on, the criminal justice end from we could say like lawyers and correction officers. I've said this before. If a person is in a certain condition, they may not need to be at that facility. So people that are being arrested, excuse my language, we have prostitutes, we have people who are drug dependent, alcoholics, and they are committing these crimes. So with bail reform, it kind of allowed people to commit more crimes because in the event of the pandemic, with all this looting, and there being bail reform, no one was really being held accountable.
Well,
So I
okay.
think
Yeah,
Right.
go ahead.
Go ahead,
Yeah.
So
Lana, go ahead.
I'll say a few things there. So the first is that, bail reform as a device to hold people accountable. Again, that's never been the purpose of bail reform. Because everybody where bail is set is somebody who is presumed innocent under the law. It's somebody who could have been wrongly accused. I think the perfect example of this is Kalief Browder. Like, he's somebody who allegedly stole a backpack, and he, until his dying day, said, "I did not steal that backpack." And bail was set on his case because of that. And he was in because of that, and he ended up dying by suicide because he couldn't take the trauma of having been in Rikers Island for so long. And so I say all that to say that if Kalief Browder was a rich man, he'd be alive today because he would have been able to pay for his bail. And so that's what bail reform sought to address, the fact that some people could get out pending trial while they were presumed innocent.
right,
and
but I
others
think
weren't.
that has a matter to do with your lawyer and how, again, you speak and present your case.
Okay,
That has it's a lot of theatrics behind it.
Alana,
Well, for all of those cases now, judges cannot set bail. Right? They just simply, under the law, a judge could not set bail on Kalief Browder's case right now. And so you're right. In many cases, back in the previous form, it did depend on the lawyer you had who could argue it as well. And that's not right either. Now, the law recognizes that, at least in some cases, there are certain people who just shouldn't be behind bars while they're presumed innocent on certain cases.
okay, Lukey, I'd like to have us go to the next questioner. Somebody else had their hand up.
Greetings, everyone, and to you, Pastor Cook. Is that me? Am I on? I got my hand up. I don't want to be rude.
Yeah.
Can you all hear me?
Yeah, you had your hand up. Go
Okay,
ahead.
I'm sorry, Reverend Cook. I'm on the. I just saw you up in Albany, Reverend Cook. I was trying to catch you on the $1 Million Staircase, but I missed you. I just want to chime in right quick. I'm going to paraphrase just to encourage the clergy, encourage the hearts of you all that are on the front lines here with the bail reform. There's a scripture, and I'm just going to paraphrase. It's in the New Testament, in the book of the Gospels, and it speaks about the shepherd who left the 99 sheep and went after the one lost sheep and brought him back to the fold. And sometimes the sheep that wandered away were so naive, and we get caught in the thinking of different things of that nature, that the shepherd would often have to break the sheep's legs and bandage them up in order to keep that sheep from wandering into the thicket or getting into trouble, possibly getting killed. My point is that one, because they're talking about a lot of those in law enforcement, different ones are saying that the ones that get caught, but you're talking about the young man with the backpack. That to me is that one sheep. So that one soul to me is worth more. I'm not saying that everybody should get away with murder. The 99 should get away unjust. No, that's not what I'm saying. But that one, further I want to commend you and all.
Okay, Alana,
I couldn't hear everything that was said there. I'm sorry about that. It's, you broke up a little bit.
Yeah, did you catch the last part? I'm sorry, I'm on the back of the bus here. I'm trying to chime in with the meeting. Can you hear me very well?
I hear you better now.
Okay. No, I was just commending you on what you're doing, and I said the Bible has spoke about the 99 sheep and the one that went astray. It's in the books of the Bible. I'm just paraphrasing for now. And the shepherd went after that one sheep, but it was so precious to the fold. You know, it was worth the sacrifice. I just wanted to encourage the clergy that are on board and those that the rest of you that are the laity that are on the front line with the bail reform. That's the fervor I have, that one lost sheep. Because you spoke about the young man. I have his picture in my bedroom, and I look at it oftentimes as an encouragement. He looks like one of my friends years ago that probably would have been in the same situation. The young man with the knapsack that was innocent and committed suicide. So I do thank you for that. And just be encouraged. But that one sheep is worth it, because everybody's saying, oh, you know, they're getting away with murder. What about? We're not saying the 99 are that are unjust should get away as well. But that one that's lost is very important.
Yeah. I mean, I would just echo everything you're saying there.
so we will want to talk about wrongful conviction, but I want to be sure we answer everybody's questions. Susan Hadley, you had your hand raised.
Yeah, I just wanted to comment also. Not really a question. I'm in vocals, so I know about the laws and stuff. But I just wanted to say that Alana mentioned Kalief Browder, and I went to the screening of the Netflix program that's coming out with his brother Akeem yesterday. And it was heart-wrenching. And I was going to say the exact same thing. You know, he was falsely accused. He didn't do what they say he did. And for him to have to go 3 years in solitary confinement, that is insane, because they set bail at $30,000 and his family couldn't afford it. So it's definitely, our people need resources. That's what we need. We need more education. We need after school programs. We need jobs that's going to pay our rent. That's what we need. So that's all I have to say.
That's absolutely right. And I'll just have one. Sorry. No, I was just going to say, thank you for saying all that. And I like that you're talking about wrongful convictions after this, because there's a very close connection between those two. So I actually used to work as a public defender before I was in this role years ago. And I was a public defender back when the old law was in place. And what very frequently would happen is judges would set bail specifically because they wanted someone to plead guilty. And so bail would get set on people's cases. They would be behind bars. And even though they didn't commit the crime, but then a judge would then say, well, if you take time, if you take 30 days, which you've already served, you get out today. So you plead, all you have to do is plead guilty and you get out. But if you don't plead guilty, you're going to be in indefinitely until we can take your case to trial.
Yes.
And so like, that's a huge part of bail reform as well, that now there's more justice actually being served, fewer wrongful convictions, because people can fight their cases from the outside. They can gather evidence. They can go to their neighbor who saw them on that day when they were alleged to have done that crime and say, didn't you see me at the store with you? And they could say, oh yeah. So and they bring that to the court. Can't do those things when you're left behind bars.
Okay, thank you. So we are going to now move. Lukey, is it okay? You had your hand up.
Yeah, I just wanted to, before Alana hopped off, just say one last thing, just to make sure that everybody was 100% clear. Bail, the amended right for individuals to be able to bail out of cases, just because of the amount of misinformation that's out there. I know that when it comes to law enforcement, the only time they don't want to use actual data is when it's things that kind of shoot down what they're trying to put out. I know a lot of people try to think that recidivism went higher once bail reform was implemented. I know you just stated that recidivism rates stayed the same, but I also just wanted to verify with folks who are on the call that the amended right for bail reform, for bail, is separate than the 2019 bail reform, correct, right?
Yes.
Yeah, I just wanted to just make sure that everybody on the call was aware that the right to be able to bail out off of a case has been something that has been around since the founding fathers. The 2019 bail reform just made it so that certain cases would be able to be released without having to pay that cash bail when the courts deem so. Just so that folks really had that clarity and that we're really moving more closer towards the actual facts and data that's out there versus the kind of the notions that we feel around crime and how we kind of feel about cases, and then also the misinformation that was being put out by law enforcement. Really looking at the actual data that does not show that a spike in crime, recidivism happened after bail reform, that the spike in overall crime was something that happened across the United States, not just New York. This was the New York State bail reform had nothing to do with that spike of crime, and that people were able to bail out prior to bail reform.
So if I could, Julian, could you describe what exactly the governor is proposing to change in her budget?
Sure. In terms of bail reform, she has proposed that the government change the bail statute by removing the requirement that judges set the least restrictive condition necessary to reasonably assure return to court. So there are two parts of that. It's the purpose of bail reform and the standard by which judges must make release determinations and detention determinations. So what it all means is that when someone comes before a judge charged with a particular crime, and the judge is deciding, do I release this person on their own recognizance, just say, here's your next court date, see you then, or do I set conditions of release, non-monetary conditions, such as substance use testing and treatment, mental health services and treatment, checking in with a pretrial supervision officer regularly, job placement and training, a curfew, electronic monitoring, many kinds of conditions of release could be set that the judge could consider. Or the judge can say, I want to set bail that you have to pay before you get released. Or for some offenses, the judge can just remand you, which means detain you. So these are the options the judge has when you come to arraignment. And when the judge is making that determination about which of these options the judge wants to choose when making release decisions, the law says that the judge must set the least restrictive means of reasonably assuring return to court. So if the judge says, you know what, I'm not sure this person is going to return to court, they seem to be a bit of a flight risk for whatever reason, I'm not going to release them on their own recognizance. Instead, I'm going to say, you need to be stabilized because you have severe substance use disorder. So I'm going to require that you see a pretrial officer, that you get regular drug tests, and that through your pretrial officer, you get set up with substance use treatment. And I think if I give you that, then that is the least intrusion on your civil, financial, personal liberties for you to get stabilized and make sure you return to court. Sometimes the judge says, you know what, I don't think there are any non-monetary conditions that are the least restrictive, the least intrusive on your liberties that are going to return to court. So I'm going to set bail, or I'm going to remand you because there's no condition of release that reasonably assures me as the judge that you're going to return to court and you're going to remain stable in the community while you await trial. And so that is what it means for there to be in the bail statute, the standard of least restrictive means to reasonably assure return to court. Now, the governor is saying, I don't want to limit the judges in that way. I don't want to hold them to this standard. And I don't want them to only consider the reasonable assurance of your return to court. I want to give judges more flexibility. And so I just want to strike them all together. and let the judge make the decision about what they want to do with that person, whether it's released with no conditions, release with conditions for bail eligible cases, bail, or remand for remand eligible cases. And the Senate and the Assembly have pushed back on that. They rejected those changes in their response to her budget proposal. And most of the advocacy community has also rejected that proposal. And so that is where we are right now in budget negotiations in Albany. And the budget has to pass by April 1st. So this is the last week during which the Senate, the Assembly, and the governor can negotiate the budget and pass an on-time budget. And bail and her proposed changes really sit at the center of those negotiations right now.
Yeah, so there are, under the old way, you could impose bail for a misdemeanor. Under the new way, you can't impose bail for a misdemeanor. You can't impose cash bail. So it's only when we talk about, so only non-cash bail things can be considered under the current law for misdemeanors. It's just that if it's a violent charge or a felony, which is bail eligible, right, that the judge would have two, quote, least restrictive options. One would be to impose cash bail, or the other would be remand. Is that right?
Kind of. So for bail eligible cases, most of which are violent felony offenses and serious felonies above that, the judge can choose from all of those options.
Oh, I see.
No complete release, release with conditions, release post paying bail, or straight up remand.
Okay.
As a general matter, when bail reform passed in 2019, almost all misdemeanors and low-level felonies were not eligible for bail and remand, meaning the judge had to either release you on your own recognizance or release you with non-monetary conditions. But there have been 2 rounds of bail reform rollbacks. So there are instances where you might be getting arrested on a misdemeanor or a low-level felony that typically would not be eligible for bail, but because of the rollbacks to bail reform, they could be eligible now. For example, if you were originally arrested for, let's say, shoplifting, right? That's a misdemeanor. It's not bail eligible. So you get arrested, they take you to the station, they fingerprint you, they give you a desk appearance ticket, and then you go to court, you get arraigned on it, and you get released on recognizance or on conditions. And then during the pendency of your case, you get picked up on another shoplifting charge. Now, typically that shoplifting charge would not be bail eligible, but because of some of the tweaks that were passed in the last couple of years, because you have committed a crime, allegedly committed a crime that caused financial harm to an identified entity, let's say a bodega, and then you got arrested on allegations of financial harm to an identified entity, let's say CDS, now you're eligible to be held on bail. And the shorthand that folks use is harm plus harm exception to the bail ineligibility of, let's say, shoplifting. Does that make sense?
Yeah, yes, it does. So, so what you're saying is that the cash, so if there's any chance that cash bail could apply for the offense in question, the judge has a range of options that they can follow, including not imposing cash bail.
Correct. So just because something is bail eligible doesn't mean the judge has to set bail or
Right.
remand you.
Okay.
So for example, there's been news articles where someone, was out pre-trial on a gun charge and then picked up some other case. That first gun charge almost always is bail eligible. The judge just decided, I'm not going to set bail, or they set bail and you pay bail. And that's why you're out. It's not because guns aren't bail eligible. Almost all of those charges are. But sometimes you either pay your bail and get out, or the judge says, you know what? Setting bail is not the least restrictive means. I think what you need is a program, or you need something else. I don't think you need to be held while you're presumed innocent. And so they set some other condition of release.
Okay, so that's what the governor doesn't like, right?
Correct.
She really wants to narrow what the judge can do to basically take away judicial discretion here, to use those two less restrictive means of just release or release with conditions. Is that right?
Well, not really. The framing she says is it actually gives judges more discretion because it doesn't limit them to the least restrictive means. So they'll still be able to release on recognizance, set conditions, set bail if it's a bail eligible case, or set remand if it's a remand eligible case. But the judge isn't required for them to set the least restrictive condition.
Okay.
And that it's not for the purposes of solely of return to court. So by stripping the requirement that judges set the least restrictive condition to reasonably assure return to court, striking that language basically gives judges unfettered power to do whatever they want. It gives them no standard by which they need to make these determinations. And it doesn't really tell them what the purpose of those determinations are. So one of the problems that a lot of us who say this is not a good idea point to is that, one, it rolls back the bail law and the purpose of bail to past what it was in 2019. The purpose of bail in New York State has always been to reasonably assure return to court.
Right.
Case law says that judges are supposed to set least restrictive means. So in 2019, they added the least restrictive means standard, which is just codifying case law. And the reasonably assured return to court was already in the bail law. So this is actually rolling back the original bail law. That's one. Secondly, it creates an opportunity for just wild bias, right? So I could go before Judge Cook in Brooklyn and get released with conditions, because Judge Cook is someone who does not want to send anyone to pretrial detention unless it's absolutely necessary. But then I could go before Judge Forbes in Binghamton, and it is same Julian, same criminal history, same allegations, but Judge Forbes likes putting people in jail. And then I can go sit in jail pre-trial for God knows how long, simply because I happened to be before a different judge. So it opens up wild disparities depending on what judge you're in front of, what county you're in, what courthouse you're in, what the judge had for breakfast, like if the judge is mad at the lawyers from the last case. It just really has creates no structure within which the judge has to make these decisions, and the collateral consequences of sending someone to pretrial detention are so enormous that we don't want there to be such unfettered discretion.
But other questions? This is really, I've learned a lot. Thank you.
Yeah, I'm always happy to answer questions too, whether it's in this forum or if you want to shoot an email and hop on a call. I'm always happy to talk through it.
Others like to ask Julian a question?
Yeah, hi Jillian. Here's Rashida.
Hi.
I'm the deputy executive director, New York State Council of Churches. And I, recall the fight for bail reform very, very, it was like yesterday. And I still think that there's a messaging issue around bail, that people don't understand that it's really intended to help, a person return, to court, and that it isn't supposed to be part of their, if they are to be sentenced, part of that penalty or anything like that. So I was just wondering about messaging and trying to convey that to legislators, to the public, that bail is not intended to just be like, well, let's keep dangerous folks off the street. If a person is truly a danger, there are ways to address that, but bail is not it.
Right. I think, yes, the purpose of bail has never been to work to consider the potential dangerousness of a person in New York. I think you're right that there's mixed messaging where people believe that the bail reforms that happened in 2019 stripped that consideration away, right? As the public thinks there was some consideration of dangerousness and that got stripped away and it wasn't. But notwithstanding that, folks like, Mayor Adams just last year was calling for the addition of a dangerousness factor. Other folks have called for an addition of dangerousness factor. And you know what? That was debated in 2019. There was a proposal when the bail reform laws, where the bail law was reformed in 2019. There was a lot of negotiation, a lot of debate across the legislature and the governor's office then around, should we include a dangerousness standard? Should judges be able to consider someone's future or present danger to the community when deciding whether or not to hold them pre-trial? And that did not get passed in the bail reform law. So, and it was just part of our democratic process, right? Where it's a democracy, there are multiple proposals, there's compromise, and part of that compromise, the negotiation and hashing out of the bail reform, did away with the suggestion that we add a dangerousness factor. Many people believed it would just increase bias because we see that Black and brown New York people generally in the United States tend to be seen as more dangerous than their white counterparts who are similarly situated. And so if there aren't due process protections that are baked in when you have a dangerous factor, you open up the potential for implicit bias in the process. Folks also argued that because of structural racism and biases within the structure of our criminal legal system, Black and brown people might have worse looking criminal records that judges are looking at when making determinations of dangerousness than their white counterparts that actually might in practice have had similar behavior in their lifetimes, but it isn't reflected the same on their criminal records. And so that was some of the conversation and the debate around whether or not there should be a dangerousness factor. And then you're right, Rashida, that it's pretrial detention, folks are presumed innocent, and there's plenty of social science research to show that pretrial detention actually exacerbates the risk of someone being rearrested or involved in criminal activity than folks who are not held pretrial for similar offenses and with similar histories. So even a day, a week, 2 months in jail, it could be criminogenic in a way that releasing folks with the services and supports that they actually need and address the root causes of their entry into the criminal legal system does a better job of preventing crime and keeping communities safe.
I want to acknowledge that Assemblywoman Latrice Walker just joined us.
And I am hoping that you are holding it down for criminal justice reform as the hour for the budget is drawing extremely near. At the moment, we're fighting for a number of things. There was just a Siena poll that was released, which indicated that 72% of New Yorkers want to see some judicial discretion, and I use that in quotes, I'm sorry you can't see me, with respect to bail. Now, judicial discretion is a really funny thing, right? Because what they're really saying is we want to have the ability to lock people up pre-trial, right? And we want to, and you have taken that right away from us, and we want that right back. And or at least the perception is that the right has been taken from them, because there's been a number of rollbacks to bail reform that have given them this sort of judicial discretion that they're looking for on the second arrest in many instances. So that being said, instead of the governor saying, okay, let's just look at that, her folk went so far as to remove the right to return to court, as well as the least restrictive measures from the bail laws, sorry. Since bail has been in existence in New York State, it's always been about ensuring a person's return to court. And then these are constitutional standards, like we didn't just make these things up. And so at this point, they're not just rolling back bail reform, they're taking our bail laws to a place that it has never been before, which is why we have to fight like, you know, nobody's business in order to preserve just what we had. Like at this point, we're not even fighting for bail reform. We're fighting a whole other thing. And, you know, it's so funny because I was talking to someone today, and I was reminded of the quote from Batman where the Joker says that the biggest trick that the devil ever pulled was to prove to the world that he didn't exist. And they got us thinking that we're fighting a bail reform war when they went 10 times deeper than that. And so we gotta, you know, recognize the conversation that we're having, and at this point is no longer about bail reform. We also look, I know there was a huge, you know, push in order for our housing laws, right? And so when I think about criminal justice reform, reentry housing is very important to that equation. And because so many people are told they can't move back to some place, or if they are able to move back, they don't have access to the vouchers that they can get in order to qualify for decent housing. And so whatever comes up, it's important for us to know that we need to have housing vouchers for individuals who were formerly incarcerated or had some interaction with the criminal justice system. And if there's going to be sort of a project-based type Section 8, 421A, 485, or whatever the iteration is going to be, it should also include something that allows for people who were formerly incarcerated to be able to live, because a lot of times people go back into their situations because, you know, they're finding a hard time making ends meet, and they're and living 2 and 3 families in one apartment. And so there's that. We're building reentry housing in about 4 maybe different developments within my district, which is in Brownsville. Partnering up with the Fortune Society and with the Women's Prison Association. And I, you know, we're trying to, of course, get Clean Slate across the finish line as well. We almost got that done last year, so people can have their records cleared after having, you know, done their time and pay their debt to society. We need people to be able to get, you know, decent jobs with some integrity, so that folks can get back to business and taking care of their families and participating in the economy. And so that's sort of my updates. But I guess, Peter, you probably have a little bit more information than me on this, as well as you guys. And so, because you're on the ground. And so I'll sit and I'll listen and take some notes, and you give me my marching orders, and I'll continue powering forward.
Well, Assemblywoman Walker, you're our hero. You're just this amazing champion on this issue, and we just so admire you for your toughness and persistence to try to do the right thing when it comes to criminal justice reform and so many other issues. So my question to you would be, how can we help stop this from happening right now in this mess?
I think at this point, it's just really going to be to keep the pressure on my colleagues, particularly my upstate colleagues, because they are pushing our leadership to roll back on bail. I heard someone today say they don't like desk appearance tickets because there's no way to track them, which I think is absurd. And so there's just so much misinformation that's out there. And so at this point, I think, folks should do robocalls or, whether there's sort of straight cold calls, just to members around the state requesting that they hold the line on bail. We need and support criminal justice reform. Emails, showing up and showing out in Albany, and really doing what we can to really let the governor's office know that we're here and we don't want you to do this so prematurely. Why are you rushing us down our throats during the budget? Like, why can't we have common sense legislation done instead of you just trying to do something in haste? Which answers, it's funny because she's a solution looking for a problem, and that's the part that I don't get. So we really got to keep the pressure on her, on upstate members, and supporting our Senate and Assembly leadership for holding the line.
Do any other people here have questions for Assemblywoman Walker? Anyone? Okay, Anne.
Yes, Assemblymember Walker, this is Ann Rabe. I used to work for the Defenders Association, and I'm just talking to you as a private citizen. I think that there's an opportunity here to get two reforms that we didn't get in 2019 on bail. One is the bill that was Senator Rivera's bill, which set up a charitable bail fund reform act. So you can have nonprofits have regional charitable bail funds, and they can provide up to $10,000 instead of a $2,000 cap to people in need. So that's one thing is, Cuomo vetoed that 2019. He broke his promise. And I think we should, that'll help people in the bail bucket.
Do you know if anyone reintroduced that bill? Because I think the Assembly sponsor was Michael Blake.
That's right, Latrice, that's right. So no, it hasn't been reintroduced, but I have a call into the senator's office, and I think it should be on the table, right? It's an important.
Well, what I'll do is I'll pick it up and see if we could work on that. Can you be in contact with maybe Isaiah in my office? And it's so good to see you and hear you. I really wish you were here. You would be such a breath of fresh air to this conversation. And so I don't know the best way to sort of really inject you in this process, but I know we were working on some other things, so let me know what your thoughts are, because you are a very vital voice, and I miss your voice in this conversation.
Well, thanks. Well, 3 people on this call said they'd like to work on this. So I will be in touch, and I'll send you over Rivera's bill tomorrow. And I'll talk to Jay in Rivera's office too, and just pass on that information. Behind the scenes as a private citizen, I'm happy to help.
Awesome.
And then the second thing real quick is something that the Vera Institute used to push. And it was never dealt with in 2019. So 90% of the pretrial service agencies in New York State on the county level are probation departments or sheriff's departments, and they take a really punitive approach in terms of not providing wraparound support for a homeless person or a drug addicted person to get the treatment or help they need to get them to court. So what we would like to see is Monroe County is a nonprofit. They provide much better wraparound support. We'd like to see a bill that says only nonprofits will do pretrial service agency services. There's been adequate funding more funding provided in the last year or two, I understand, but it's got to be from nonprofit organizations that are there to support people, not take a punitive approach.
Okay, got it. Got it. I remember, I think there was also some conversation about that as well. Maybe it was from my conversations with you, but I do have to run. So Ann, can you call me tomorrow, please?
Sure, will do. Thank you.
Awesome, awesome. Thank you. So I do see I see folks comments in the chat box. You are right. Dangerousness is a racist. Judicial discretion equals racist dangerousness assessments pretrial. That is exactly it. And so we got to do everything that we can in order to stop that. So Ann, I'll look for your call tomorrow. Peter, thank you for inviting me, and to everyone else, Godspeed. We just gotta keep doing what we gotta do.
Our prayers are with your mom and with you, and we got this, and you gotta care for her as best you can. So, I think what I'd like to conclude by saying here before we go to wrongful conviction, if it wasn't clear up till now, I'd like to make this clear now. From this New York State Council of Churches perspective, we're just urging people to say no to the bail proposal from the governor. Just say no. And, as you can tell, this has a lot of complexity. And we just don't think that what she's proposing does anything to help, but does a lot to harm. And it's just better in this case to do nothing. Rashida, would you introduce our next guest?
Absolutely. This year also being considered with this other slate of legislation around the criminal legal system is the wrongful conviction bill, which is being championed by many organizations, but also primarily by Vocal New York. And we have a member on the line with us, Roger Clark. If you are able to unmute yourself, I would love to turn this over to you to lead us through a conversation around the wrongful conviction legislation.
I'll be happy to. Thanks you for having me. Like she said, my name is Roger Clark. I'm a Vocal New York leader, and yes, and let me say something about wrongful conviction. I believe that it is fundamentally wrong for innocent people to be sent to jail, while the innocent perpetrator remain free to commit other crimes. When an innocent person is convicted of a crime, it is not only harmful to the individual and their family, but it also disrupts the entire society. The challenging wrongful conviction bill that is now before the Senate is a bill that is designed to help those who is already convicted of a crime. If you're convicted of a crime in New York State for a crime that you did not commit, or for any reason, like let's say, you convicted, your direct appeal is finished, and you have an issue, you have evidence or issue to prove that your conviction was obtained in violation of law, the only avenue we have is through a provision called Criminal Penal Law 440.10. But however, that provision currently is too stringent. It is hardly anybody is able to meet the perimeters of it. So what we did was we changed it. Like today, if you were to file a 440, you don't have access to an attorney. Once the challenge from wrongful conviction is passed, you will have access to an attorney. The same thing is true for evidence, even though the legislator passed bail discovery and speedy trial in 2019, the discovery version only go up from 2020 forward. So anybody who's trying to get their evidence before 2020, the prosecutor would tell the judge he don't have a right to get that. And we want to change that. And a judge could simply dismiss your case without a hearing. So we want to make sure that they're given a hearing, you know, and their case is adjudicated. You know, once we make a prima facie showing that your case has merit, they should be able to hear it and rule according. You know what I'm saying? And this is what the challenging wrongful conviction does. It is true what the counsel said just now when she was speaking about bail reform, is that in too many cases before the bail reform provision was in place, individual will languish in jail. This is what prosecutors want. They want you to be in jail, to not be given bail, to not be given evidence. You don't know what the prosecutor got against you. And then they come and they pressure you. They use a pressure tactic between them and sometimes the court-appointed attorney, and they literally coerced me in 29 when I was 20 years old to take a plea. You know what I'm saying? For a crime that I did not commit, and that is not right. And I want to right that wrong, because that is like a black cloud over me, and it's not going to stop until I get it over with. You know what I'm saying? So yeah, the bill right now, it passed the assembly last week, Wednesday, and it's currently in the Senate. We're hoping that it passed sometime after the budget is finished. And we're hoping to pressure the governor for her to sign it as well and make that become law for once and for all. So yeah, it is wrong. It is wrong. There is too many, according to the Innocent Project, New York State ranked 3rd in wrongful conviction. And we believe that we are a little bit more on top because of the so many cases that they have been able to hide away. But once they get access to that courtroom, I believe we probably number 1. Yeah, so those are the provisions. Does anybody have any questions?
Okay. Rashid, I see Dwayne has his hand up.
Yes, that wasn't for a question. I just wanted to speak on the wrongful conviction, as well as my brother just so eloquently spoke of. What's good, bro?
All right.
All right.
Yeah. Did you want to say anything more?
Oh yeah. So so my experience with the criminal justice system is I was wrongfully convicted, not once, but twice. And now I'm being maliciously prosecuted by the Manhattan District Attorney. My first wrongful conviction started off in 1996 when I was accused of robbing a crack addict, me and my co-defendant. And the plea offer was 3 years, and I rejected that offer, trusting God, because I'm a man of God. And I went to trial, and I blew, and I got 5 to 10 years for a robbery I never did. Me and my co-defendant never did. And it was during that time back then that I started learning the law for myself. And I found out how I was convicted because my attorney didn't ask for a redirect on after the DA cross-examined me. And that attorney, that criminal attorney now works for the Bronx DA's office. And it is something that I've seen not only with my case, but it's happening with other cases as well. As a paralegal and as someone who worked in the law libraries in prison, I saw a lot of people's cases where they copped out the things they didn't do, just to talk about what my brother Roger was just saying. And they know that the DA doesn't play fair. And so they know that they can get out of jail right now if they just cop out versus taking a chance and going to trial with an attorney who 9 times out of 10 probably won't have the time or the day to put into your case, because they overswamp or for whatever reasons that they may have. So I've been able to mentor these youth in prison by getting them involved with their cases and bringing the law to the facts of their case. And as a result, one young man by the name of Carlton Campbell was able to use my mentoring services, and he was able to get himself a favorable disposition where he was indicted on 21 counts of robbery back in 2010. And he had told me he was innocent when we was on Rikers Island. And I reviewed his paperwork, and the arresting officer didn't identify his name, but was going around showing a single photo identification to all the non-Black citizens. And they all said that they were strangled from behind. So if he was strangled from behind, how was you able to identify this young Black man? The only reason why they put those cases on him was because he was on parole for robbery already, young Black coming up in the hood. He doesn't know anything. He doesn't have any resources, but he knew one thing. He knew he didn't do the case. So he knew that to come to the law library to hopefully get some help. And as a result of that, he was able to articulate for himself before the judge by asking the question who the arresting officer was. By that simple question, because the arresting officer's name was never identified in the paperwork, the judge turned to the ADA and says, well, who is the arresting officer in this case? That's a good question. And so the ADA said, well, we don't know. But then before he can get out the court, they wanted to settle the case. And he took time served. Okay, he'd been fighting that case for like 14 or 18 months. He took time served on 21 counts of robbery that he didn't do. And now here I am in 2023, I'm still dealing with something with the Manhattan District Attorney where they now have fabricated and manufactured a domestic violence case against me coming out of the 34th precinct that is known for corruption. They're getting sued left and right for manufacturing cases and beating people up and planting evidence. And I was arrested in 2018, in September, for this case. And through the grace of God, I'm out on bail right now through a miracle. I was able to get a lawsuit while I was on Rikers Island because I was assaulted by some gang members. Okay, and because of that lawsuit, I was able to get the bail that I needed to get out. And that was just in time for the pandemic. But since I've been out, I've been able to not only advocate for myself, I've been able to advocate for thousands of other people, into bringing addressing the purple elephant in the room. We just had a meeting with City Council, Carmen De La Rosa, just the other day with Vocal. And now she wants to look into getting oversight for the prosecutor's office besides just the budget. Because how does the NYPD and the prosecution office keep coming every year to keep asking for an increase in budget when you don't come with clean hands? This type of behavior of rewarding bad behavior has to stop. And if we can get all the communities and organizations out there to push this, because I like to call it hashtag make them pay. Because at the end of the day, for every wrongful conviction, that family that has been traumatized by that is paying for it. The taxpayers pay for it to foot the bill on the lawsuit. And the person, when a person is wrongfully convicted, then the guilty remains free. So that person that's out there committing those crimes, other citizens are paying for this person's crimes that the prosecution failed to get. So at the end of the day, who's been held accountable? The citizens of New York. The prosecutions and NYPD have never been held accountable. And we need to have this attitude of make them pay. So thank you.
Thank you. Annika Roche, you have your hand up.
Yes, hi. So my name is Anika Roach and I'm out of Brooklyn. And I just wanted to say in regards to bail reform, in addition to wrongful convictions, that it really is important that we fight to have these things implemented in our criminal justice and in our laws, because it is more likely that we'll have more issues like this than not. And there are people that have been illegally stopped and arrested, and I've actually had that experience, not in this state but in Florida. My son was stopped, arrested, detained, and he actually served like 33 days in jail because he fit the description. And the description was just a Black person with black shirt, black pants, black shoes. And the person had a low haircut and my son had braids, but it didn't matter. And the interesting thing about the whole ordeal was I paid a lawyer that was deliberately dragging the case out to make a trial for a case that didn't even need a trial. So sometimes, you know, as a minority, we are at a disadvantage because here it is, even when you have resources to fight a case, you have to hope and pray that that lawyer has your best intention at heart. Now, I had a public defender for him at first, but the public defender didn't even meet with him until the day of his court date. And so I had to hire another lawyer in place of the lawyer he had. So imagine that's three different attorneys. I had a public defender that I replaced for another lawyer, and then I had to fire that lawyer to get another lawyer to represent him so he can get out. And the body cam showed a guy that looked like Drake. And here it is, like I said, my son had long hair. Even in court, he showed he did not fit the description. It did not change the fact he did not get a bail. It did not change the fact that he sat there on a charge that he had no business in jail for. And that's something that we have to take into consideration when we think about wrongful convictions and bail reform, because at the end of the day, how many people are sitting there that don't have resources? I spent $10,000 to get my son out of jail. $10,000 that I really didn't even know I had until he got in jail. But when you have loved ones, you do everything you can to try to protect them and help them and get them out of those situations. But some people just don't have those resources financially. And they are a lot of people that are sitting in there because of wrongful stops and frisks. You know, I am a criminal justice major that just graduated last August from John Jay College, okay? And when I sat in that court in Florida and I watched how that lawyer that I paid for represented that case, it was my schooling that let me know he did not represent my son at all, because I took a Fourth Amendment class and I understood that it was a basic argument that he could have used to get my son off and get him out of this case, and he neglected to do anything. I went to the office. I spoke to the boss of the owner of the law firm, and I terminated them. And I made it known to that court, to that not the court, to that law firm, that I had asked for the transcript of that hearing, because I was going to report that lawyer to the bar. But everybody don't always have that kind of knowledge at their fingertips to know what else to do. And it's so important that we embrace these reforms that we're asking for because of that.
Okay. Thank you. I'd like to let Neil ask his question and then see.
Yeah, this is really simple, Roger. Just address the fact of the trauma that when you're wrongly convicted from day one, the trauma.
Oh, all right. Oh, yeah, there is a lot of trauma, a lot of stress. When you're wrongfully convicted, there is thousands of things that you cannot do. You know what I'm saying? There's a lot of jobs that you cannot no longer have. You know, you cannot get certain permits. And the trauma don't only affect the incarcerated individual, it affects their parents too, and everybody who comes and visit them. Because going into a correctional facility in upstate New York, where most of those were at least from my experience, a good majority of those correction officers, they don't necessarily like people my skin color, you know what I'm saying? And they have killed from Comstock to Attica to Clinton, you know what I'm saying? So the trauma is real. The only thing I'm gonna say is that what everybody said is valid, is a valid argument. By implementing the wrongful conviction act, New York can take a significant step towards ensuring that innocent people are not wrongfully convicted and imprisoned, and it will set and restore, hopefully will set and restore a little bit of public trust in the criminal justice system, and will clear a clear message that the state is committed to protecting the right of all citizens. You know what I'm saying? We need to get this stuff off of our record. You know what I'm saying? It gotta happen. Thank you.
Dwayne, did you have a last comment? I'm sorry.
Oh, that's from earlier. I'm sorry.
Okay.
But yes, one thing I didn't mention was that as a result of the manufactured domestic violence case that's been going on since 2018, the NYPD and the Manhattan District Attorney have fabricated the body cam footage. They edited the body cam footage and they changed it when I was locked up in Rikers Island. And when I was in the prison law library, they came in there and changed the footage. And I've been requesting the audit trail logs. And I've had 5 court-appointed attorneys. I'm on my 6th court-appointed attorney right now. And I've always told my previous attorneys that they tampered with the footage. And then next thing you know, they're telling me that I'm lying. They wouldn't do that. That's criminal. And they wind up getting off my case. So just recently, we had this hearing with the city council, and they're going to push the Manhattan District Attorney to look into this case and dismiss it based upon the time factor, which is speedy trial, and the fact that you haven't turned over the audit trail logs, which is part of automatic discovery. You know, so with that, hope things will work through. And this case is dismissed, so I can move on with my life, because I haven't been able to do anything, you know, as a result of these bail conditions that's over me. You know, so I just want to throw that out there as well. There's a lot of corruption. Thank you for allowing me to speak.
Thank you. And it's important that people feel like they have a voice, and we want to create a space for that, because I think sometimes people feel like they don't have a voice in this system. I'm looking at Ann Rabe, who has her hand up, but I want to just conclude here and just ask, could it be restated again exactly where this wrongful conviction bill is at this point? I guess it was out of committee in the Senate. Is it also out of committee in the Assembly?
No. Well, let me reiterate again the history of the bill. Last week, Wednesday, it was on the Assembly floor. 2 Wednesdays ago, the bill passed the committees in the Assembly, and then it was on the floor for like for a couple of weeks ago, the beginning of March. It went through the committees, and then it stayed on the floor. Then last week, Wednesday, I hear music. Yes, last week, Wednesday, the whole Assembly passed it. It was passed 90 to like 50 something. So now the bill is currently in the Senate. The bill is currently in the Senate. The Senate's lead sponsor is Zellner Mari. So we're working with his office. We're trying to speak to central staff and everybody else to try to see if we could put it on the committee, so that once it leaves the committee and it goes on the floor, then hopefully it will pass. It currently have 30 senators, and one senator agreed to sign on from Staten Island, but she hasn't submitted her slip. You know what I'm saying? So it have 30 senators.
Okay. Thank you for that update. So I'd like to with everybody's permission, Anne Rabe is with us. And Anne worked for the Public Defenders Association for many years and was really involved in getting bail reform passed. And while she's working in environmental justice now, she has a lot of background on this issue. So Anne, I'd like to just kind of give you the floor if you could, if you have questions or statements you'd like to make.
Oh, thank you, Peter. Yes, everyone, as a private citizen, just, criminal justice reform is close to my heart after working on it for 9 years. There's 2 outstanding bail reform bills that will really help lift up people who are charged with a felony or a misdemeanor and can't afford bail. One was vetoed by Governor Andrew Cuomo in 2019 when the bail reform law passed. At the budget, his chief of staff said, "Oh, we promise after budget, we're going to do the Charitable Bail Reform Act." Didn't meet that promise. It was passed in the Senate and the Assembly, and it was vetoed by Governor Cuomo a couple of months later. And what this does is, right now, there's only like 3 or 4 county-based charitable bail funds in New York State. The ones in New York City have largely shut down in the last couple of years. And so we have a really oppressive state law. It says you can only have a charitable bail fund on a county level, not regional, and you can only provide bail to people a 2,000 cap, which means basically only misdemeanors. So we went, this Charitable Bail Fund Reform Act, which Senator Rivera, who's still in the Senate, was a champion on, would lift that cap to 10,000. So it would cover many felony, not all, but many felony charges, and would make it regional. So we could have 6 or 7 regional bail funds, nonprofit organizations that would provide bail and also provide wraparound support to help the person, innocent until proven guilty, get to court. So it's a really important bill. And I have a call into a couple of people in the legislature. I mean, bail's on the table now. The governor's, trying to roll back the bail reforms. This is a great opportunity to get the Charitable Bail Fund Reform Act passed. So we at least are providing, a bail fund to people, and they don't have to go to the bondsman. They don't have to, go bankrupt or whatever. So that's one. The second reform is the pretrial service agencies that are supposed to be getting people support when they're charged with a crime, getting them support to ensure that they can get to court if they're homeless, if they're drug addicted, etc. They're supposed to provide that support system. Well, 90% of them are run by the probation departments. So they take a very, very punitive approach, and they don't provide very good wraparound support to people in trouble at all. I mean, there's a handful of them. I guess Monroe County is supposed to be a decent one. But what we need is reform of the pretrial service agencies so that they're nonprofit organizations, not the probation department, not the sheriff's department, which they are 90% of the time. There's a handful of them that are nonprofit, but they should be nonprofit, and we should have specific criteria. You need to provide wraparound support to someone who's charged with a crime, and whatever that means in terms of giving them a house if they're homeless, treatment temporarily, etc., so that they can show up in court and get their day in court. So those are the 2 reforms. I'd love to talk with anyone who's interested in pursuing them. I mean, we have a window of opportunity in the next week or 2 with bail. So that's my 2 cents.
Lukey, are you Lukey?
Yeah, I'm here.
Yeah, could you just talk about the 413 and what that's about?
So the 13 Forward bill is a bill that would make a constitutional change to New York State's constitution that basically allows for slavery in New York State. Right now, when a person is incarcerated in our state prisons, they are deemed to kind of be less than a human being and considered a slave. This allows for them to not have proper work safety, as well as allows for their wage to be under $1, really roughly about 35 cents at cap. This is really inhumane, and across the country, other states, including Utah, have already started to opt into laws like this that will change that and allow for individuals to now be able to be paid a decent wage, allow for that workforce safety to be implemented. We have inmates inside of our state prisons that weld, that work with dangerous chemicals. As we see during 2019 COVID, the inmates were the ones that produced a mass amount of hand sanitizer, and actually were restricted from also having access to that said hand sanitizer. We're seeing a system with the 13th Amendment in our New York State Constitution and overall United States Constitution allowing for slavery to be implemented. We're seeing Corecraft and other industries and companies that are able to really generate income off of this quote unquote slave labor that we have right now. This itself can kind of be deemed to help promote this tough on crime narrative that continues to keep these types of systems going. By really addressing this overall and allowing for people to be paid a decent wage, we're allowing for families to kind of be able to not have the burden of having to provide for their loved one while they're incarcerated, and also empowering those incarcerated people to now know what it seems like to have a legal job, working a legal job, getting a decent salary, and possibly being able to support their loved ones on the outside, as well as sustain themselves and them too when they're released, having a nest egg that they're able to go home with. These types of changes not only take the burden off of the taxpayers, as it will help reduce the recidivism rate, reduce the amount of people that are pulling on support when they're being released from prison. Allowing for this constitutional change is so important. Unfortunately, we're going to have to get it passed twice in order to get this constitutional change to happen. So this is something that we're looking more as a post-budget demand versus a pre-budget demand, because we can get it passed anywhere throughout session and it still be valid. So we're looking to get this passed twice consecutively in order to really get this to be something that is passed into New York State law. There hasn't been too much pushback around it because it's really cut and dry. It's not really too hard to, like, it's not really too much you can say to really like make it make sense why paying people a low wage considered slave makes sense, as well as only a paragraph. So if you speak with legislators and they said they haven't gotten a chance around to read the bill, they could read the bill. It's only a paragraph. If folks have any questions, I'm definitely able to answer questions, and we'll be able to pass it on to you. I can also pass you on more information as to where to follow up with.
Hello. Hi, Ronnie. We're just getting to the end of this call, but we want you to get the last word in here. Could you say quickly, could you first speak to the question of prison wages? We just discussed the Forward 13 bill amendment, which would basically say that people in prison would have to be paid a comparable wage, and it's an amendment that goes before the legislature. But I know that you also, I imagine you're supporting that, but also if you have anything else to say about prison wages.
Okay, am I frozen or do you guys still see me okay?
We got your you know, your
Freedom.
logo.
Okay. So in regards to the prison wages, there is the 13th Ford. I don't know if you guys talked about that. And I'm working with that. And also yesterday they had a fair wage rally at the Capitol. And I spoke there in regards to they're trying to push for men and women who are coming home to receive unemployment for a few months. And so we spoke about that because my first time coming home in 1990 versus my last time coming home from prison in 2005, they were still giving the same $40 in a bus ticket to get home, which they still are giving the same $40 in a bus ticket. And the expectation is, let's just say I'm coming from Albion, Attica, or further up. The expectation is if I have to get to Long Island, I have $40 in the bus ticket. That bus ticket will only get me to Grand Central Station. Beyond that, that $40 has to get me on the Long Island Railroad, whatever bus I have to take here, they'll ever get a Metro card, because the Long Island Railroad from Grand Central Station has to get to Penn Station. And so by the time you get to Long Island, wherever it is you're getting, Queens, wherever, you have just about exhausted your $40 in the bus ticket. Don't even think if you're stressed and you want to buy a cigarette, that's out of the question because that's almost half your money, right? And then if you're a woman, which we try to do to Sisters Healing Old Wounds, you have any female issues going on, you can't even get yourself that through that $40 in a bus ticket. So we tried to give out dignity bags and we try to get them in the hands of re-entry programs throughout the state. We also worked with Suffolk County Jail, Nassau County Jail, Albany County Jail to have these, in Schenectady County Jail, to have these dignity bags. So when the women went home, they would have them. So it's just something, we could never get docs to sign on to get the dignity bags into the hands of the women coming home from prison. But if you're making 11 cents an hour, and if they got any type of surcharges on you while you're incarcerated, it's not easy to try to save up a few dollars upon your release. It's almost an impossible thing if you have no family or anybody else between. I mean, I think industry workers might make 17 cents an hour. I think that asbestos workers make about 25 cents an hour. So, I mean, and now that they stopped allowing the families to send packages in through the mail directly, you're at the mercy of having to buy from these vendors, which they also hike prices. So you're in a lose-lose situation if you're coming home from prison with the wages and everything else that you're facing. So we're trying to work to get them to raise the wages that the men and women have. I fought hard and had to get Assemblyman John McDonald to get our fall requests honored that we submitted to get the document that shows each and every program that the men and women have throughout docs and what the pay rate is, and it's absolutely disgusting. Again, it's the same exact pay rate it was in 1990 that it is today. Same $40 and a bus ticket coming home. So it is a setup. There is no corrections in correctional facility. It is a setup from the word go. All right. And, you know, even when you think about transitional services and what that really looks like, that's a joke. So everything they do, to me, when it comes to any kind of wages for an incarcerated individual, is a setup for recidivism.
Okay, thank you, Ronnie. Okay. All
So
right.
I just wanted to touch bases with what you were just talking about, and as far as not-for-profits getting involved with the wraparound providing services. But I think also that there also be some type of form of training for these not-for-profits that we can be able to get involved with this type of thing.
Yeah,
you
yeah,
know?
yeah. So I'll organize a Zoom call with you, Anika, and Ronnie and Lukey later this week.
Yeah,
Okay.
that sounds good for me.
Okay.
Sounds great.
Okay.